Hi, this is Tom Azoni. I'm a senior partner with Seacrest Wardle in Troy, and today my partner Doug Moseley and I want to talk with you about dram shop litigation in Michigan. Doug and I have been doing this kind of work for many years. In fact, we both started our careers handling dram shop defense cases on behalf of insurance companies you've probably never heard of before. Companies like the Stonewall Jackson Insurance Company, American Universal, Canadian Universal, and Transit Casualty. These companies have gone out of business, and for a very good reason, because earlier in our career, back in the 70s and 80s, the dram shop legislation was much different then than it is today, and it was much easier for a plaintiff to recover against a bar arising out of an accident. And as a result, these insurance companies went out of business because of the weight of all the claims and judgments that were entered against their insureds. So today the act is very different, and Doug is going to start off telling you about the history of the legislation. I'll come back and speak to you about the defenses that are available, and then Doug will talk with you about some important cases and the current status of litigation today. All right, here's Doug.
Hi, my name's Doug Moseley, and I'm a partner with the firm Seacrest Wardle. I've been doing these cases with Tom in the same firm and in different firms for many years. The Dram Shop Act is a very unique piece of legislation. There's versions of it going back into the 40s. The statute that I worked under initially was adopted in 1956. It creates a cause of action, recovery against liquor license holder, which overserve customers, who then cause injury to another person. And this can be an automobile accident, a fight, a shooting, a stabbing, all kinds of carnage. Pool balls, pool cues have made for great cases under the Dram Shop Act. Now, the cause of action is a statutory cause of action. It's indicated in 1956, and there's never been any kind of act before that in common law. So when you deal with the Dram Shop Act, you have to deal strictly with the statute as it is written. And many attorneys, and Tom will talk about this in greater length, have tried to find ways around the Dram Shop Act, but they've pretty much been stopped in doing this. And again, the Act creates a cause of action or recovery against a licensee, either a retail establishment, a liquor store, a party store, a grocery store, a bar or a restaurant that oversells, and then the alleged intoxicated person, or the AIP as we insiders call it, causes an injury to someone else. The problem, the original statute, when both Tom and I started working with these cases, I had some major problems. The first was the tortfeasor. The AIP discovered it was far easier to get out of a case by cutting a deal with the plaintiff's attorney. In other words, he would admit that he was visibly intoxicated, or he was drunk as a skunk and the dude drop in, and either for a minimal settlement or just being dismissed altogether, it would be out of the case. And the bar, of course, would be dumped on because the case involved the sale of alcohol, and we've already had the one person admit that he was very, very intoxicated. So when the bar owners and their lobbying groups found that this was going on, they petitioned the legislature and got an amendment. This is called the name and retain provision. And this held that the plaintiff could not bring a dram shop action unless the actual tortfeasor was brought into the case and retained in the case until its conclusion. And that's up on the board now. And the courts have been very strong in upholding this, to the point that they said that a plaintiff's attorney must use due diligence, devoted and painstaking application to finding the alleged intoxicated person, serving him with a cause of action, and unless the suit is settled with the bar, the plaintiff can be the case can be dismissed if the plaintiff's attorney settles with the alleged intoxicated person. Now, this part of the Act has been around for a long time, so you don't see it as much as you used to, but it did provide some assistance. The other problem with the Act that caused even more trouble for the liquor industry was the fact that the original Act allowed mom and the kids to collect damages when dad got hurt after drinking in a local bar. And they were entitled to loss of income, loss of support services. It could add up very quickly. And this part of the act was so egregious and caused so much grief that the liquor industry in Michigan and the insurance industry had a major problem on its hands. The only policies you could get were very, very expensive. The big companies stopped writing the coverage, and it was you'd pay a very high premium just to get some protection. So finally, the liquor industry and their lobbyists had begun a campaign to get reform. They were joined by other businesses that needed reform, particularly doctors and malpractice cases. And in 1986, the legislature revised the entire tort system in Michigan, and one of the key components was the Dram Shop Act. And that limits recovery to bars and restaurants, recovery against bars and restaurants. It required that the dram shop defendant maintain $50,000 of coverage at all time or remain a surety bond, but it set forth a series of revisions that have helped the industry out. As Tom indicated at the beginning of his talk, this webinar, that there were many companies that literally went out of business and many bars that couldn't stay open because they got popped for a judgment and they had to sell the place to do business. Revisions that were adopted, things got back on even scale, and Tom's going to talk to you about the various provisions in the Act and what's happened with the Act and how that has helped both the industry, the bars and restaurants, and the companies that write liability coverage for them.
This is Tom Azoni. I'm back. And so we're going to talk about specific defenses under the Dram Shop Act. Now, as Doug told you a moment ago, the Act is entirely statutory in Michigan. So under Michigan law, any claim that arises out of the sale of an alcoholic beverage by a licensed liquor retailer must fall under the Dram Shop Act. And as Doug has told you, the Act has changed dramatically over the years as the liquor industry has lobbied for protection against the scope of claims. In response, the legislature itself has perceived overreaching on the part of plaintiff attorneys and have shown a willingness to narrow the focus of the Act. The appellate courts have chipped in and have played a significant role in both shaping and limiting the cause of action under a liquor liability claim. So let me give you an example. Under the Act, you'll find that a drunk person, the drunk himself, has no cause of action. But this hasn't stopped creative plaintiff attorneys from trying to plead around the exclusive remedy provision of the Dram Shop Act and to try to find a negligence cause of action under the common law that might allow the drunk himself or herself to recover. So, for example, a claim has been made where the bar employee did not adequately train its employees to spot that the drunken person was intoxicated, or a claim that the bar's employees were negligent in failing to engage the customer in conversation to see whether or not that person could be served another drink, or that the lighting was poor in such a way that the bar was negligent and the poor lighting prevented the staff from seeing that the customer was intoxicated or had bloodshot eyes or the like. And my favorite one is the claim that the bar failed to adequately give a ride home to the drunken person. Now, all of these attempts reached the Court of Appeals on these claims, and all of them failed. And they failed because the Court of Appeals recognized that the Dram Shop Act is the exclusive remedy for all claims made for the sale of alcohol, and that would encompass any of these extraneous kinds of claims. And so they have all been rejected. All right, so as we go on, let's talk about who can be liable under the Dram Shop Act. Well, the only party that can be liable under the Act is the liquor licensee. That is, the company or person that holds the liquor license issued by the state of Michigan. So what about employees of the bar or restaurant? Can they be sued because they served someone who was visibly intoxicated or who was a minor? The answer is no. Only the liquor licensee. Well, what about a homeowner who holds a Christmas party at his or her home and serves someone until they are intoxicated or visibly intoxicated and they get in their car going home and hurt someone? Can they be liable under the Dram Shop Act? The answer to that is no. The same as if you, in your employment situation, attend a Christmas party at your office sponsored by your employer. Is the employer liable for the fact that someone has too much to drink and hurts someone? The answer is no. Now, there is a common law cause of action that we could discuss in another webinar, but those claims are centered on whether the homeowner or the employer provided alcohol to a minor only. But under the Michigan Dram Shop Act, only the liquor licensee is liable. All right, next issue in this litigation is, well, how long does the plaintiff have to bring a cause of action? The answer is it's 2 years. It's a 2-year statute of limitation and not 3 years as you would commonly find in a negligence claim. And well, why is that? Well, the legislature responded to complaints by bar owners that 3 years is simply too long a time to find witnesses and former employees who tend to move around frequently. And consequently, as part of the legislative process, they reduced the statute of limitation period to 2 years because of that problem that bars have in trying to locate former employees and witnesses who might remember a particular event. The next important provision under the Act is the notice provision. And that provision is contained in the same statute. It's 436-1801, Paren 4, that's on your screen. And that provision is another important defense or provision that assists bar owners to help them locate employees and witnesses quickly. The person representing the injured party must, in writing, notify the liquor licensee within 120 days after that person enters into an attorney-client relationship whose purpose it is to pursue a claim under this section. Now, there's a very important limiting language in that section. So keep in mind, this is not a notice provision that says that the attorney must give notice within 120 days after he's hired as the attorney for the injured party. That's the common misconception, because that attorney could be hired simply to pursue the auto accident claim or the PIP claim or the third-party claim against whoever hit the plaintiff. But it's 120 days after the attorney takes on the Dram Shop case. So a smart plaintiff's attorney will have an amended contingency fee agreement with his client at the time that he intends to begin working on the Dram Shop part of the case. And that amendment will be the date that triggers the start of the 120-day notice provision. Now, that notice provision must be in writing. It must be sent to the liquor licensee, not the bar necessarily, but to the liquor licensee, and they're not always the same, not always the same location. And there's only one defense available, or one excuse that is available to the plaintiff in not complying with the 120-day notice provision, and that is that the plaintiff or his or her attorney did not know which bar was involved or could not have found out which bar was involved with due diligence. So how might that come up? Let me give you an example. Let's just say it's a very serious traffic accident and the drunk has a criminal charge against him arising out of that very accident. The drunk person would plead the Fifth Amendment while those criminal charges are pending, and so the plaintiff and his attorney would be unable to talk to the allegedly intoxicated person to find out where he drank alcohol, and assuming that that plaintiff's attorney has no other information available to him as to where that intoxicated person got his liquor, well, then he's pretty much precluded from identifying the bar and satisfying the notice provision. So that would be an available excuse. But otherwise, that act, excuse me, that notice provision is strictly construed by the courts. It's 120 days. You must do it. It must be in writing. It must be sent to the license holder, and it must identify sufficiently the accident to allow the bar and its employees to begin accumulating information and evidence about the incident. And if you don't comply, it's a complete bar to the plaintiff's claim. All right, so next important provision is the indemnification provision. This is a benefit that was given by amendment to the Dram Shop Act to accomplish a very important goal, and that is to make sure that the alleged intoxicated person does not reach an agreement, privately of course, with the plaintiff and the plaintiff's attorney to give favorable testimony in return for some kind of relief. You know, perhaps they won't pursue a judgment that they get against the AIP or some other kind of secret deal that might be reached between them. Under this act, the bar is entitled to a statutory indemnity claim against the alleged intoxicated person for any amount of damages that are awarded by a jury or a judge against the liquor licensee. So, what does that mean? As a practical matter, what that means is that the AIP's, in an auto setting, the AIP's auto policy becomes primary and the bar's policy becomes excess. The second practical effect of that statute is that because the AIP knows he is being sued by the bar, it is highly unlikely that that AIP is going to enter into some secret sweetheart deal with the plaintiff's attorney when not only are his insurance assets at risk, but his personal assets are at risk as well, because the indemnity provision under the Act is not limited to the AIP's insurance policy proceeds. It's a claim brought by the bar against the AIP individually for indemnification. So the one question that comes up is, well, what if the bar settles at some point during litigation? Can the bar then pursue a cross-claim for indemnity against the AIP? And the answer is no, because when you see the statute in the language is there on the screen, the indemnity provision applies to all damages awarded against the licensee. So only a judge or jury can award damages, so clearly this would not apply to a settlement. But this provision is effective. Your attorney should be filing a cross-claim for indemnity in your first response of pleading when they file their answer. The cross-claim against the AIP simply would say that you're relying on the statute and expect to recover any amounts that a jury or judge awards against the licensee for claims made against it by the plaintiff. And then what do you do as the claim rep? If it's an auto case where there's an insurance policy afforded to the AIP, you sit back and you wait until that policy is offered. If the case can be settled within the policy, you offer nothing. If it's a big case, your position is you'll do nothing until the full policy limits are offered. That's the practical effect of that indemnity provision, and it's important you understand how it works so that you can use it most effectively for your insured. Under the Act, let's talk about legal defenses. Under the Act, all defenses that are available to the alleged intoxicated person are available to the bar. Sometimes it's hard to wrap your arms around that concept, because there are defenses available to the bar you wouldn't think ordinarily would be available to that bar. So let's talk about the two common cases. So first, a bar fight case. So what happens in a bar fight case? Two people get into a fight, and who brings the suit? It's whoever lost the fight. So the loser sues the bar and claims, well, the guy that hit me or hurt me was drunk, and you, bar, you served him until he was visibly intoxicated, and that's what caused him to lose his temper and hit me, and the plaintiff always claims to be an innocent victim of an unprovoked assault. It's almost never true, but that's the claim that's always made. So what defenses does the bar have? Well, in addition to all of the other dram shop defenses, including notice and all the rest, didn't serve him while he was visibly intoxicated, the bar has all the defenses that the AIP has. And what are those? Well, one, self-defense. So contrary to the claim of the plaintiff, often the AIP said, no, it was the plaintiff who was the aggressor. I was simply acting in self-defense. The main defense to an AIP in an assault situation is that they mutually consented to a fight. And under Michigan's common law, if two people mutually agreed to a fight, the loser can't sue. It's called a consent to a mutual affray. And so that defense is available to the bar. Comparative fault by Michigan's tort reform. Comparative fault is available now even in an assault setting. So if the plaintiff is at all voluntarily engaging in the fight, even though he got the worst of it, there is the defense of comparative fault that the bar can assert. In an auto setting, all of the no-fault defenses available in a third-party auto action are available to the bar. So for example, the bar can contend as one of its affirmative defenses that the plaintiff did not meet the no-fault threshold, or that the plaintiff did not have an objectively manifested impairment, or that there is no causal relationship between the accident and whatever injury the plaintiff is asserting, and on and on. So that's an important provision that can be overlooked, and it just you need to be aware of it when you think about valuing your case and the exposure you might have under a claim. Think in terms of not just the defenses the bar has to the liquor claim, but to the whole spectrum of defenses that might be available to the plaintiff's claim. All right, the next defense that's available has to do with minors. All right, so a minor's cause of action is a little bit different, only in the sense that a minor, that is someone who's under the age of 21, not 18. So in Michigan, the legal drinking age is 21. A minor is considered anyone who's not 21 for purposes of drinking. So anyone under the age of 21 who either directly or indirectly is served alcohol, who then becomes intoxicated and then injures someone, creates a cause of action on the part of the liquor licensee. So there are a couple of things that are important there. One, it doesn't have to be only a direct sale. So imagine a party store where the minor is outside, and as an adult comes in, the minor says, hey man, would you buy me a case of beer? I'll give you the money, and I'll give you another $5. And so the adult goes in, buys the case of beer, and the minor, in view of the employee, is seen getting that alcohol. Is that a potential cause of action against the liquor licensee, even though it did not directly sell the alcohol to the minor? The answer is yes. Secondly, the important thing to understand is there is no element of visible intoxication in the claim that a minor was sold alcohol. Just the fact that the minor is under the age of 21 is the illegal portion of the sale that creates the cause of action. There is a defense to this, however, and the sole defense is that the minor produced either a driver's license or a state ID card that appeared to be genuine. Well, appeared to be genuine screams of a question of fact. But you know that kids today, and with today's technology, they are able to create masterful fake IDs. And it's a real problem in the industry. But nonetheless, if the bar is able to secure the ID that was used by the minor to obtain alcohol, oftentimes this is an excellent defense because of the quality of those fake IDs. But oftentimes it's a question of fact. Some kids are sloppy, and with some scrutiny, you might be able to determine that it's fake. And then the question becomes, did this particular ID that was used appear to be genuine? And often that's a question of fact. The next issue to be discussed concerns who can sue under the Dram Shop Act. It's not quite a defense, but it's an important point to know what is the scope of the act. And so we talked about earlier that the drunk person himself can no longer sue in Michigan. But it's also important to understand that the family of the drunken person can no longer sue in Michigan either. When Doug and I were first practicing, this was the most common cause of action. That is, the drunk person leaves the bar, let's say hits a telephone pole, and then the claim was brought by the drunk person's wife or children, claiming that he was served while intoxicated, and as a result of his accident, they've lost his support and companionship. Well, what's the problem with that cause of action? Well, the problem was that the most energetic witness favoring the plaintiff's cause of action was the co-defendant, the father. So the drunken person, who would be a defendant in the case, is siding with his family members to say, oh, yes, I was drunk. Oh, I was stinking drunk. I was falling down. I barely got to my car. And the bar quite often had no one to counter that testimony. And consequently, those cases were routinely won or settled for high value because of the very odd nature of that kind of claim. The legislature responded, and currently that claim is no longer available. So you need to be a true innocent party in Michigan in order to recover under the Dram Shop Act. That's one of the key themes throughout the appellate cases, is that the liquor liability claim, the legislation, is intended for innocent people only, and unfortunately, the family of the drunken person does not qualify. That used to be part of an appellate case, then it was codified, and now it's part of the statute. There's the next issue concerning multiple bars. And we know from what pub crawls are about, and it often arises in college towns and certain industrial centers where there are strings of bars that are located one after another in a close geographical area, and parties will move from one bar to the next, becoming more and more intoxicated. When we used to do this work quite a lot, one of the worst places was on Dort Highway in Flint, because someone would get off their work shift in the afternoon and would start at one end of Dort Highway and work his or her way down to the other end, and during which they might attend 5, 6 bars, and followed ultimately, of course, by the crash. And then the lawsuit would involve the AIP plus 5 or 6 bars and a plaintiff who was severely injured. So the legislature has reacted to these kinds of claims as well. I would have to say not in a particularly effective way, but they have offered some protection to the liquor licensee by creating a presumption that any bar in a string of bars, which is not the last one, there is a presumption that there was no illegal sale. So you just sort of have to think about that and get your arms around it. So there's no presumption that affects the last bar, whether it's for or against an illegal sale. But for any bar prior to the last bar involved, there is a presumption that there was no illegal sale. So when I say why is that not an effective protection, well, the problem is presumptions can be easily overcome. And if they have a good case against the second, third, or fourth bar, and they have someone who says, yeah, he was drunk in that bar, and that witness is effective, your presumption is essentially gone. So it does provide some of an arguing point, a point that can be raised both in the claim stage and during litigation. I just find that in the course of an actual trial, it doesn't really win the day very often. At this point, I'm going to turn it back to Doug, and he's going to talk to you about some issues that involve current litigation, and then he's going to wrap up. It's been nice talking with you. Call us if you have any questions.
Hi, I'm Doug Moseley again. I'm going to talk to you a little bit more about what the Act's like now and how we see it being interpreted by both the courts and how we deal with some of these issues. Under the revision, under MCLA 436.1802, this legislature stated that there must be a liquor licensee shall not directly, individually, or by a clerk or agent or servant sell or furnish a minor, or sell or furnish a visibly intoxicated person. Now, as Tom indicated, there's still a cause of action if a minor is sold. You do not need to prove visible intoxication to a minor, just that they sold and that there is a relationship between the tortious behavior caused by the alcohol, that was caused by the alcohol. So that's always a problem for us. We always work with our clients to make certain that they're doing things to maintain a carding system that's organized and followed on just about every person. I've seen various things that work. There's always one that can slip through, so minor cases are upsetting. But most of the cases involved adults, and that's when the phrase visibly intoxicated being adopted by the legislature helped us out a lot. Now, the Dram Shop Act does not define visible intoxication, but you have before you the Michigan Civil Jury Instruction for Dram Shop case, and these are the definitions. Intoxicated means that you've been affected by the alcohol, when it affects your senses. But visibly intoxicated requires some observation and some objective proof. A person is visibly intoxicated when his or her intoxication would be apparent to an ordinary observer. And the use of the phrase ordinary observer has been very helpful to us. It helps us when we're dealing with cases of good friends and family members, because they're not ordinary observers. They've seen the alleged intoxicated person behave in an intoxicated manner. By using an ordinary observer standard, that we get away from the friendship. We get away from people who know how this man or woman behaves when they've been out drinking alcohol. It also helps us with the police. The police are trained at a much higher level to discern signs of intoxication when they're doing a field sobriety test. So we're able to minimize the impact of police officer testimony as well as family members with that language. Now, we've found a couple of pictures here that show you what we're looking at. I think we can pretty much all agree that the lad at the bottom photographs is visibly intoxicated. The bartender there should pick up that drink and call his mother or anyone else or his friends and get him out of the bar, make sure he's not driving. although there's no requirement under the Act that the bar do that. The only restriction is not to serve a visibly intoxicated person. Now, with the photograph of the women, that might be visible intoxication, or they might be just having a darn good time, and that's the problem with these cases. One thing you're going to find when you're dealing with the licensees is that there are two separate training divisions or schools in Michigan. One is the techniques of alcohol management. The other is the TIPS case, techniques in protective service, something along those lines. And they are both ways of training the staff of a bar or a restaurant as to what behavior to look for. The more I'm looking at the women, I'm beginning to think they may be across the line. But with TIPS has a green, yellow, and red light testing, and they put out specific signs to watch for. Clearly, the young man has reached red. The women are probably yellow and should be watched very carefully. So when we would try these cases, it would be our job as defense counsel to help the jury understand that this visible intoxication, obvious to an ordinary observer, is the key. And our job was to establish that visible intoxication had to be pretty darn serious. So we would start with what we called the parade of horribles. We would ask questions about whether or not the person had gotten sick, whether or not the person had the AIP had fallen down, whether or not the person had balance problems, had fallen off his chair, had knocked the person down, stumbled or staggered. Obviously, slurred speech is always an issue in these cases. But once we get the jury thinking about the terrible things that would distinguish an intoxicated person from a non-intoxicated person, we would go into the other sides, and that would be coordination. Was the person able to get his wallet out, get his ID out? Was the woman able to get her money out? Did she have problems adjusting her purse when she was sitting at the bar? The way they were sitting, did that seem to cause a problem? And again, you always get down to slurred speech and bloodshot eyes. Now, bloodshot eyes can be anything from allergies to medication or to alcohol. So we're able to beat up on that a little bit. So what we did find, though, with these cases, and many of them involved driving problems, was that the key component in the proofs was the blood alcohol level. And that can be tested by either a blood test or a breathalyzer test. PB test results are not preliminary preliminary breath test results are usually not admissible in Michigan. And then both sides would get their experts and they would line up and you would put your case on. And that system worked for a long time. We would settle cases, we would try cases, but the experts sort of took a forefront in the terms of proving visible intoxication or lack of it. And then the Supreme Court took a case called Reed versus Breton versus the Beach Bar. And they quote, the cite for that case is up on the screen now. And the issue of the case, there were a couple. One involved whether or not the rebuttable presumption for the last bar, but the key was the type of proof used by the plaintiff to try to defeat the bar's motion for summary disposition. Now, the trial court had granted summary disposition on the Beach Bar's motion. Court of Appeals reversed, finding that there was sufficient evidence presented to create a question of fact. And the evidence that the plaintiff had used was an opinion letter from a toxicologist who said that the AIP would have shown signs of visible intoxication given his blood alcohol test results that were taken after the accident. The Supreme Court, the trial court didn't find that sufficient, and the Supreme Court jumped right on it. It too decided that there has to be more than circumstantial evidence. And the quote that is most cited in this case is in front of you. And basically what the court is saying is the experts, the opinions, the amount of time drinking, the number of drinks, the condition of other drinkers in the group are not sufficient. You can't rely upon that alone. There must be a testimony that the person actually manifested signs of visible intoxication, which are observable by an ordinary person, the ordinary observer. By taking this position, the court eliminated a lot of cases involved which were based on circumstantial evidence, primarily blood alcohol test results. And the amount of filings diminished greatly. We think that they might be tipping up again. There has been some movement in the Court of Appeals to deal with this, but it's still a viable law. There hasn't been enough problems with it for the Supreme Court to get involved and revisit the issue. So at this point, if you've got a case where there may be some circumstantial evidence, but you still need evidence of a person displaying signs of visible intoxication. You must have a witness saying, I saw the AIP with bloodshot eyes, balance problems, gait problems, slurred speech, etc., etc. And without that, the case is open to a motion for summary disposition, and we've had quite a bit of success with that. Now, is that going to be the state for all times? Who knows? We do have prepared a list of Court of Appeals cases that have dealt with or interpreted Reed versus Breton versus Beach Bar. I have that available, and we have that available to you. And if you want a copy of that, we'll be more than happy to get that to you. The courts have found some breakage. We've seen some of the dam, some cracks in the dam created by the Reed case. And we've got cases where the number of drinks was sufficient to support the case. We've also got a Court of Appeals case where the number of drinks was not enough to support the case. So it's going to go back and forth, and we don't know where it's going to end up. But right now, the bars and the restaurants and the retailers are in pretty good shape under the Act, which means both us as defense counsel and you as claim representatives dealing with these cases are in pretty good shape as well. But it's good to know what the Act is all about. So during the initial interviews with the clients and with the license holders, you can start to get a feel for what's happening, what the place is like. These are all questions that have to be dealt with as the case goes along. Now, this is the most important slide I've been told. Has the contact information for Seacrest Wardle. We thank you for attending the Dram Shop Primer webinar. You've got both Tom and I, and as you can see, we have been doing these cases for a darn long time. So if you've got any questions about anything about the Act or some cases, a set of facts you can't figure out, or need some help in determining when certain parts of the Act come in, please feel free to contact us. I want to thank you very, very much for attending today, watching this. Have a good day, and thank you.